Good morning. If you're joining us on YouTube, you're welcome to watch, but I'll remind you that recording or reproduction is prohibited. You can be held in contempt of court. Joining us now is our court reporter, Ms. Michelle Stewart, and I have allowed you to record.
Thank you, Judge.
Okay, good morning to Probate Court 2. When you are connected, you're going to be on mute, so I'm going to ask you to unmute yourself. We are live streaming on YouTube this morning. This is the estate of Francis Meints, and I've let everybody in that's on the waiting room, or in the waiting room. We are on Zoom, and it is typically my policy that if anybody rings in the waiting room, then we will let them in, just as if they had walked in the courtroom, so that they can be a part of the hearing today. This is the other half of the de novo hearing. I think Mr. Catterton had asked for more time on one of the accounts, and looks like Mr. Sellers has decided to join us, so we'll let him in. All right, as I was saying, this is the other half of the de novo hearing regarding some of the accounts in this estate, and Mr. Catterton had asked for more time to get some more information to be able to make some decisions. So counsel, will y'all please announce yourself for the record?
This is Bill Catterton, the temporary administrator.
James Snyder for J.C. Cullum, the dependent administrator of the estate of Virgil Meints.
Ryan Sellers for Michael Coker.
Okay. I believe this de novo was brought by Mr. Snyder, so you can go ahead.
Thank you, Your Honor. As you mentioned, we continued the hearing on issues 2, 3, and 4 as they pertain to the 1087 account on our first amended application for partition. Just a brief review of the facts pertinent to this hearing. Virgil Harlan Meints died on December 13th of 2017. He died intestate and was survived by his wife, Frances Meints, and his 3 biological children from a prior marriage. Frances later died on January 14th of 2018, and Mr. Catterton qualified as the temporary administrator of her estate on September 26th of 2019. During the course of the administration of her estate, he received the proceeds of the 1087 account, which is a JP Morgan securities investment account held in the name of Virgil Harlan Meints. He received 100% of the proceeds of that account and is now claiming that Francis' estate owns 100% of the funds in that account pursuant to a transfer on death agreement for a Bank One Securities Corporation investment account numbered 65G690723. As the party...
Okay, Mr. Snyder, we are live streaming on YouTube. Please don't give any full accounts again.
My apologies, Your Honor. I'll refer to it as the Bank One Securities account, and I imagine that'll be enough for everyone to understand what I'm talking about. As I stated, he recovered the funds. He is now claiming he owns 100% of those proceeds. And as the party claiming 100% of the proceeds through a right of survivorship, Mr. Catterton has 2 burdens of proof which he must establish. First, he must present evidence that TOD agreement does in fact apply to the 1087 account. As I mentioned, it is a Bank One Securities Corporation transfer on death agreement with a different number than the 1087 account with JP Morgan Securities. And Mr. Catterton must present competent admissible evidence that that account was in fact taken over by JP Morgan and at one point remunerated into the JP Morgan account. Second, even if we are to even assume that the transfer on death agreement does in fact apply to the 1087 account, then that account must be a written agreement, or excuse me, that transfer on death agreement must be a written agreement signed by the account holder, in this case, Virgil, and it must specify that his interest survives to the named beneficiary. Now, in order to establish that third element of survival, there must be some language contained in the agreement that the interest survives or vests in Francis Meints as the named beneficiary. As we have looked at this transfer on death agreement, There is none of that language. It is wholly void of any survivorship language, which is required by not only the Texas States Code, but also Texas case law. First, Stauffer v. Henderson is the seminal case on this issue, a Supreme Court case from 1990, and it states that no presumption can be created to contradict the written agreement or supply a term that is wholly missing. As I mentioned, this transfer on death agreement is wholly void of any sort of survivorship language, and Mr. Catterton, even given more time at this point, has not produced any competent or admissible evidence that establishes this right of survivorship. All he has is this written agreement that makes reference to some other document that he is claiming may or may not exist, but he has been given no evidence to show that it in fact does exist. It is his burden of proof to establish that it does exist. We cannot sit here and just assume that it does exist, and beyond that, even assume what language is contained in that agreement. Now, and that he cannot introduce any sort of extrinsic evidence, such as conversations with any sort of JP Morgan employees, to establish either the fact that this transfer on death agreement does in fact apply to the 1087 account, or that there is that requisite language, or that that agreement ever existed with specific language. To summarize, Your Honor, Mr. Catterton has been given ample opportunity to find this evidence that he needs to overcome the presumption in Texas that this account passes through Virgil's probate estate. He has been administering Francis' estate for over a year now, and in fact, you gave him more time to find this information. He has failed to do so, and we are requesting, based on the evidence that we have, that you declare that one half of the proceeds of this account are in fact owned by Virgil's estate, and requiring Mr. Catterton to deliver one half of the proceeds to my client, Joseph Clyde Colum, as the deed administrator.
Mr. Catterton?
Yes, Your Honor, first I'd like to just briefly address this ample time that counsel references. The first contact with JP Morgan and this JP Morgan Chase in this account occurred back in February of 2019, when attorney Mike Caldwell, who's with the firm where Mr. Snyder has eventually gone to work for, subpoenaed business records from JP Morgan Chase, and in those asked for, including the ones for account number 1087. Those things were responded to, and all that JP Morgan sent back was essentially statements for different accounts, one of which was this 1087. Those records all reflected the name of Virgil and showed it as a TOD account on the statements. They provided no signature cards. They provided no transfer on death agreements. None of those were sent back to them. The court then appointed me in September they took no further action to look for those, and the court contacted me appointed me in September of 2019, and we started gathering the information. Among the information we obtained was this JP Morgan Chase account. And in going forward with that, we sent them back in the early part of this year, 2020, an application for distribution of the funds on the brokerage side. It was showed as a transfer on death account. JP Morgan issued us a check for the 200,000 plus. They were put into the estate account for Francis in this matter. In February, roughly when this was occurring, Mr. Snyder was already expressing reservations. He'd come into he was not here initially when this occurred, but he'd come into this and was expressing the same concerns he's expressed today, which I won't go through again. And then when this money came in, we're at the end of February, and let me just point out, for a time factor, when we're talking about ample time, we were then on the threshold of this age of COVID, where everything unfortunately frequently has been slowed down. In fact, in my conversations with JP Morgan, they told me in the March.
You're safe.
Okay,
I'm sorry, this is just a background, Your Honor, but they advised that what had taken, pardon me, Your Honor?
It's fine, it's argument.
Okay. They advised me that what had been taking them a few weeks was now taking a few months to respond to. We then went forward with the thing, and of course, the court knows what has been filed to now. And let me just now respond to the legal side of this thing. this matter. In our brief, we pointed out to counsel and to the court, responding to the three reasons why he says this is not valid. One was that the account number differs. The temporary administrator in August last month, after the court gave me time to try to gather this, sent out a request for production to JP Morgan Chase. And all we requested in those was only documentation pertaining specifically to the 1087 account and its predecessor accounts. In response to that, JP Morgan has produced the Bank One Security Corporation thing, which the court has before it, the transfer on death agreement, and a table of contents reflecting the 1087 designations as the account in question. Historically, in the mid 2000s, JP Morgan merged with or took over Bank One. The documents that JP Morgan produced reflects this Bank One transfer on death agreement as the predecessor account in response to these sworn requests for production. I've noted in my brief that it's been held that when there's evidence that his account has been renamed, renumbered, the original account agreement is sufficient to create survivorship effect. And those cases are well set out. The fact that these numbers are changed, you don't have to redo them every time. And there's a number of cases we've cited, and I don't think there's an argument in the law about that, that they don't need to sign a new agreement every time an account is renewed. And of course, they've identified this as the predecessor account.
Mr. Catterton, how have they identified this as the predecessor account? Is there a business records affidavit? Or
Yes.
Okay.
Your Honor, there's a business records affidavit which they sent back in response to our request for documents regarding predecessor accounts to the 1087 account that we're talking about here today. And Your Honor, I'm just gathering funds. Counsel, that's my job in the case. But in reviewing it and trying to find the nature of those funds, they've identified this as the predecessor account, the Bank One account, in request to the subpoena we issued and with the business records affidavit. The part about the TOD agreement doesn't define or describe the rights as required by law. Well, that's slightly doesn't directly answer it. It shows it as a transfer on death agreement. It designated Francis as the beneficiary to receive 100%. And in the transfer on death agreement that's been proved up through JP Morgan that Virgil Meints signed, which is the court has as part of the subpoena records that have been filed, and as well as my response here. Virgil Meints signed at the bottom as an account holder signature that he had read, understood, and agreed the terms of the transfer on death disclosure agreement herein. And he signed that when he was assigning it. Now, our request for production to JP Morgan, and the reason I've given some history on them is it's like pulling teeth sometimes. We had asked in our fourth document to be produced that they produce all documents regarding transfer on death disclosure agreements referenced, including transfer on death forms. They didn't respond to that at all. We would, of course, in this matter, like to go back and request this transfer on death disclosure agreement, which is referenced in the transfer on death agreement, which was proved up by business record affidavit. We think that this court should make a finding that the Bank One transfer on death agreement that transfer death agreement that we've produced pertains to this 1087 account, which is what they've said under the request for production, and that the Bank One account is a predecessor account to the 1087, because again, the business records affidavit, when they produced it, said this was the document. We only got about 3 documents back, and they said this was the document. We would like to be more thorough in this, to go back to JP Morgan again and ask them again, okay, thanks for that. We want that transfer on death disclosure agreement if it exists. on the request for production and get that additional document to further lock this thing down. If the court wants us to go that direction, we'd ask this be continued or this continuance continue on this aspect of the case. And let me say something about the case. And I'm not sure what the rush is from, I know counsel would like to get the money, but what the rush is legally, this money account is in a estate account. It's got a $500,000 bond on it. The money's not going anywhere. And rather than rush ahead and say, okay, we don't care how slow JP Morgan may be in responding. And let me point out again, this started with Mr. Caldwell and Mr. Snyder's firm where they were not fully responsive to what he requested. Let's forget about that. And even though we've now got this transfer on death agreement, let's stop the discovery and just split the money up. And I suggested the money's fully protected. We ought to be given an opportunity to go ahead and do it if the court wants us to. I work at the pleasure of the court. If the court wants us to find out if there really is such an agreement out there. That's all we have, Your Honor.
All right, Mr. Sellers.
Yes, Your Honor. I'm going to give you 3 reasons why this application should be denied with prejudice, and 1 reason why you absolutely cannot grant it. I have a wholly different understanding of this case than the other attorneys. Let me start with this. This is an evidentiary hearing. The Estates Code provision that this partition application is brought under is 360-254. 360 deals with partition in various aspects of estates. 254 deals with jointly owned property. It provides that an owner of a joint interest in an estate can ask the court for partition. In order to have this burden on Mr. Catterton to show, you've heard a lot of argument this morning, Your Honor. To my understanding, you haven't heard any testimony and you haven't seen any exhibits, and nothing's been admitted. The burden at the outset.
We're still in some opening statements.
Are we? Okay. Well, I don't think that you're going to see any evidence that you can say proves that Virgil Meints had an interest in this account. I expect that the argument is going to be that these account numbers don't match, so you can't consider it in regard to the transfer on death provision, but that by that same rationale, you couldn't consider the signature card either. So either all of it comes in under the business records affidavit or none of it does. And if all of it does, then we have to give effect to the transfer on death agreement. That's first. Second is that partition is not the correct cause of action to try to get the relief they're seeking. What they're asking for is the court to order Mr. Catterton to turn over funds to the temporary administrator, or the, dependent administrator of Virgil Meints' estate. The funds have been distributed out of the account and are now held in a estate account by Mr. Catterton. I just, we only got the documents in a week ago, and this was an issue I wish I would have been able to brief to the court in writing. I just haven't had the opportunity to do so. But I'm going to present that I've reviewed all of the cases and authorities submitted by the applicant, the movement in this action, and none of them are by partition. All of them are declaratory judgment, conversion, and in some cases, sort of other things that are way out there, like partnership accounting and theft under our theft statute. But point being, there's not one out there for partition. And I looked, and there's only 4 cases in our case law citing this particular provision. They all deal with real estate. So I just don't think there's authority to say that partition is the correct cause of action. I think I'm going to kind of just move past one of these. So we're just going to call it 3. But lastly, this application requires citation to all interested parties. I reviewed the record, and Michelle Goodson, she's Jennifer Michelle Champion now. She also goes by Michelle Goodson. She is the adverse party in interest to my client, Michael Coker. The applicant, Michael Gray, doesn't take under the will. He's simply the appointed PR. Under the will, Michelle and her descendants would get everything. If we go with intestacy, my client gets half. That's the gist of it. But she has more of a dog in this fight than anybody, because either she gets all of it or half of it. She hasn't been issued citation. She hasn't filed an appearance in this case. And as far as I know, Nobody's been keeping her up to date because, from my understanding, and I'll represent to this court, my client has been keeping her up to date on the proceedings going on in this court. It's an awkward situation, to say the least. But if you look at 360-254, it says that the other provisions relating to partition apply to this to the extent that they're applicable. And if you look at the second subchapter that deals with citation, you'll see that all interested parties are required to be issued citation in addition to the personal representative if one is appointed. Lastly, Your Honor, this is costing too much. We've now had 3 hearings on this partition application. I think we have like a $45,000, $50,000 swing here. And I think we've already spent that amount of money fighting over this. I urge this court to put an end to this, deny their application with prejudice. In the event that it doesn't do that, I mean, if you grant this application, Michelle can come in tomorrow and upset it. So I don't see that we can go forward in granting it. I would just urge the court to deny it with prejudice.
Yes, Your Honor, just briefly to address everything that Mr. Sellers just mentioned. He has not given notice for any of these defenses or denials or anything to our application, as he's required to give 3 days notice before presenting any sort of argument. So I would ask the court disregard everything he just said. But for the citation issue, I will say that Mr. Catterton, as the temporary administrator, represents all potential interested parties in that estate. I believe Ms. Goodson would take under the estate, and if I'm mistaken by that, I'm happy to be corrected. But if she does in fact take under the estate, then she is being represented by Mr. Catterton, and Mr. Catterton has the only standing and capacity to actually represent and defend an action in this matter. Now, as
y'all filed the motion for partition, correct?
yes, Your Honor.
Okay. Mr. Catterton is a temporary administrator. While he owes fiduciary duties to those people who may inherit in the estate, whether through the will or intestate, he doesn't really represent them. He's serving at the request of the court because of all the issues in the case. So I think Mr. Sellers was talking about the partition issue. But
correct. But again, sorry, Your Honor.
Okay, go ahead.
But again, to Ms. Goodson only has an interest through the estate. The estate is being represented by Mr. Catterton. There is no individual interest in this partition matter that has been established by any of the potential heirs, takers under the will, or anyone else in that may have claim or have an interest in the estate of Francis Gerardo Meints. The only person that has actually established interest or capacity, standing, what have you, for this estate and to defend actions against this estate, which we brought this action against the estate, is Mr. Catterton.
Okay, anything else?
No, Your Honor.
Okay. Anybody like to call any witnesses or offer any evidence?
Your Honor, Bill Catterton, temporary administrator. Your Honor, I would just like to introduce into evidence and put into evidence the materials that we've already filed with the court that were returned pursuant to our subpoena to JP Morgan account, which includes that transfer on death agreement and some other records, all with a business record affidavit they returned it with. And we'd just like those in evidence before the court.
What are those attached to, Mr. Catterton? I see an exhibit 1 to the supplement that you filed on 9/25/20 at 4:43 p.m., but that appears just to be 1 page.
Well, there are actually 2 pages, Your Honor. One was the table of contents and one was the transfer on death agreement. The table of contents that they produced in response to it showing this was the 1087 account, which is the attachment 2 to my motion today. It numbers the pages and shows that number 3.
Okay,
that
so
number
you're offering attachment 1 to your supplement and attachment 2 to your supplement. Is that correct?
That's correct, Your Honor.
All right, any objections?
No objection, Your Honor.
Okay, they're admitted. Anything else? Okay. I'm going to take a look at some of the case law and I will get back to you as far as what my ruling is. Mr. Catterton, if you want to take that time to see if You can get anything else like the disclosures, then that is fine. I mean, certainly we want to seek the truth here. And I know Mr. Catterton really doesn't have a dog in this hunt other than he has fiduciary duties owed to the estate. So, but he doesn't have any personal interest as far as receiving any of the money. I also am going to encourage you guys to get your clients together, and Miss Goodson and Mr. Coker maybe together, because it does seem like you're spending a lot of money going after what, even if you split it in half or one estate gets all of it, it's going to be eaten up by a lot of attorney's fees. You guys might want to look at that. All right. And I think the will contest is in the ancillary. I severed that into the ancillary, so that will get, that's actually set for trial November 17th. Now,
I think that's subject to our most recent Supreme Court order, or second most recent. No jury trials until December unless we can go get permission from the local administrative judge and the regional presiding judge.
yes, they're supposed to have that out by October 1st, but I'm not going to hold my breath. So I plan on not going to trial just because of waiting on the Texas Supreme Court, as well as there's quite a few lawsuits filed right now on these emergency orders. If the emergency orders are held unconstitutional, the Texas Supreme Court has no authority to give the orders that they have given. Then they fall and you're back with your jury trials, and you guys are back in person in the courtroom as it should be. All right, let the record reflect Bill Catterton gave a cheer to that. Back in the courtroom, especially for evidentiary hearings. I think you guys should be back in the courtroom. But I will not spend your time and your client's money discussing that. I will let you guys know when I make my decision, and if there's anything else that comes up, if you'll please file that and bring it to the court's attention.
Well, Your Honor, one last thing. I did start on a brief. I wasn't able to get it in shape to file with this court in time for the hearing. We only got the documents in a week ago. Is there a time where I could get it to the court by, if you would review it after the hearing?
Well, if you'll get it in by Friday at noon,
I can do that.
I don't think I'll rule before Friday at noon. And also, I know Mr. Catterton's going to look for some of the disclosures that he mentioned. So, all right. Thank you all very much. Have a good rest of your week.
Thank you, Your Honor.
Thank you, Your Honor.